That's a Pinto. Sanjay Pinto.
A lie can travel halfway across the globe while the truth is still putting on its shoes. Fake or letterhead journalists pollute the stream of information, and they pose a threat not just to genuine media persons but also common citizens and the freedom of speech and expression itself guaranteed under Article 19(1)(a) of the Constitution of India. With no in-house accountability that other journalists would be subjected to, these namesake media persons care two hoots for the reasonable restrictions in Article 19(2), such as defamation, public order, or incitement to commit offences, and they reduce free speech to a free-for-all. The line gets blurred all the time. Towards this end, there was a well-meaning order of the Division Bench of the Madras High Court in Shekaran versus State of Tamil Nadu, this was in 2021, and the court had directed the Tamil Nadu government to constitute a state press council. Why? To predominantly tackle the menace of individuals masquerading as journalists. At a recent hearing, the first bench of the Madras High Court, led by Honorable Chief Justice Munishwar Nath Bhandari, had rightly wondered if there was a statutory provision for such a state-level body. The fact is that the Press Council Act of 1978 only provides for a Press Council of India at the central level under Section 4. For a state body to have that gravitas, it needs to draw its legitimacy from a statute, like state human rights commissions do under Section 21 of the Protection of Human Rights Act 1983, like state information commissions under Section 15 of the Right to Information Act of 2005, or state bar councils under Section 3 of the Advocates Act of 1961. As the power to make rules in the Press Council Act is vested with the central government under Section 25, a state enactment pursuant to a judicial nudge in this case was the only way out. Now, after a bit of a flip-flop, the government had filed a compliance report setting the stage for Tamil Nadu to arguably be the first in India, the first state in India to form a local press council, Tamil Nadu Press Council. It's a laudable move, no doubt. As newspapers figure in entry 39 of the concurrent list of the 7th schedule of the Constitution, a law that is passed by the State Assembly will of course need presidential assent to obviate repugnancy under Article 254(2). Now, while the legal nitty-gritty can be worked out, as a practicing advocate before the Madras High Court and a former national TV journalist, bureau chief and resident editor, I do feel that the real question is whether the purpose for which this body is constituted will be served. It may be pertinent to recall an admission of the Press Council of India before the Supreme Court in Ajay Goswami versus Union of India 2007 that it has no jurisdiction over the electronic media. An attempt in 2017 to amend the Act to bring the electronic media under its sway did not come through. The Press Council had further lamented before the Supreme Court that it, and I quote, enjoys only the authority of declaratory adjudication, with its power limited to giving directions to the answering respondents arraigned before it to publish particulars relating to its enquiry and adjudication. It, however, has no further authority to ensure that its directions are complied with and that its observations are implemented by the erring parties. Lack of punitive powers with the Press Council of India has tied its hands in exercising control over the erring publications, unquote. So, when the parent body, the Press Council of India, has been admittedly toothless with just the limited power to censure under Section 14, it is imperative to ensure that a branch, a state branch as it were, is suitably empowered to rein in misinformation and misconduct without treading on the right to free speech. That's going to be the challenge. While there is a self-regulatory body for the electronic media and recently even for digital platforms, the State Press Council will not be able to loop them in. Why? Because broadcasting and other forms of communication fall under entry 31 of the Union List, on which only the central government can legislate. Now, interestingly, unlike section 49(1)(d) of the Advocates Act that empowers the Bar Council to regulate the standard of legal education and consequential enrollment of advocates, which itself the Supreme Court feels needs further tightening. There is no entry barrier for journalists, no professional body to look into the standard of journalism education in the country. Aside of TV channels, there is a clutch of independent YouTube channels that have lakhs, even millions of subscribers. Not to forget independent journalists who contribute to multiple media outlets. Then, of course, you have people who are on the social media whose followers may be several times that of the actual readers of the publications they work for. Many opinion makers, many of these YouTube channels, independent journalists, deserve accreditation, but also a code of conduct that should come with it. A feasible way of bringing all these platforms under a common umbrella, infusing external accountability, ensuring certain standards, is to link accreditation that grants access to the corridors of power to the State Press Council's disciplinary arm. Suspension or cancellation of accreditation that can be publicized, quite like the Bar Council disciplinary action for a breach of ethics or other misconduct, may just have a salutary effect.